all of our NAREP familia. Thank you so much for coming on today. We know that we have this threat that has been a huge conversation across the nation on what's happening in our real estate industry today is a very important topic and a great conversation that we're going to have. Okay. The theme of this, as you saw, is the future of real estate industry. Is this the end or the new beginning? I truly believe that this is a new beginning. However, this is the time for all of us to really come together take a stand of what's right, not only for our real estate professionals, but for all of our consumers and within the Hispanic community. And together we really can make a difference. So before we get started, I of course want to share with you guys of all of the incredible people who are going to be in this conversation today. We have our National Board of Directors who are present. We have our chapter leaders who are present. Welcome our partners regionally and nationally. Of course, our NAREP members from all over the nation. Please let me know where you're from. I am seeing everyone on the chat today. And without further ado, to really have an incredible conversation of the future of our industry, I want to welcome our panelists. First of all, we have the Chief Legal Officer and Chief Member Experience Officer with the National Association of Realtors, Katie Johnson, who's joining us today. We will also have our NAREP President-elect, my sister, Nora Aguirre, who will also be on this incredible panel. And of course, the one and only, our fearless leader who is so behind this issue that we really all need to get behind and take some major action in, is our co-founder and CEO of NAREP, Mr. Gary Acosta. Please, ladies and gentlemen, help me welcome this incredible panel for an incredible conversation today.
Thank you, Nuria. Thank you, Katie. Thanks for joining us today. I know that you're in the midst of the national conference for NAR here in California, so we really appreciate you taking time to chat with us and our members today. This is, as Nuria says, a very important issue. One of the biggest issues that I think our industry has been confronted with in recent history. But I thought we'd start off by having you just kind of give us a synopsis of the judgment, the lawsuit, basically the status, and maybe some of the things that we're most concerned about moving forward.
Sure. Thank you very much, Gary and NAREP. Thank you for inviting me and giving me this opportunity to speak with your very engaged members. So what we're talking about today is the recent verdict in one of multiple class action lawsuits challenging the traditional practice of offering compensation over the multiple student service. So this case specifically, which we refer to as Burnett, was class action attorneys representing sellers in Missouri who used one of 4 MLSs located in Missouri. And they claimed that those MLSs followed a rule which NAR required, which we might call the compensation, offer of compensation rule, that requires listing brokers to offer compensation in any amount to buyer representatives. And quite specifically, NAR's rule is that it can be any amount. We've always advised it's been from a penny to anything. Most recently, you may have read that we were asked, could it even be 0? And the answer was yes, because the difference between 0 and a penny is insignificant. The rule itself states the purpose of the rule, and that is to inform buyer representatives of the amount that they would be paid before they endeavored to do the work. It is a one of many tools and pieces of information that make the MLS efficient and transparent and motivate those buyer brokers to bring buyers to sell the home. So the plaintiffs, sellers, allege that NAR and our corporate defendants, there were 4 corporate defendants originally. That's Anywhere, Remax, Berkshire Hathaway Home Services, and Keller Williams. The allegations were that those corporations, they are not real estate service providers. Those companies that were sued with NAR were franchisors, and they allege that those franchisors required in their franchisee agreements that the franchisees be members of NAR. And then they allege that the rule that NAR promulgated led to artificially fixed and inflated prices being paid to buyer representatives. The plaintiffs there allege that buyer representatives are unnecessary now in light of technology. In both the opening and closing arguments, as well as briefs throughout the many years, they've claimed that the role of the buyer agent is insignificant, and that it is the rule that is artificially propping up the use of buyer agents. They claim that that buyer agency would disappear without the rule, or it would be accessible only to the affluent. And they said that's okay. And we disagree. That is not okay. That is not what's right for consumers. That is not in the best interest of home buyers or sellers. And we had the opportunity and the obligation really to explain to the jury why the plaintiffs have it all wrong. So we were in Kansas City for 3 weeks, begin in mid-October. Presenting our evidence, and the plaintiffs presented a story of David and Goliath, the big corporations taking advantage of sellers, which couldn't be farther from the truth, as you know. And the defendants provided 10 days of evidence and testimony that showed the value that realtors provide to consumers, that explain the rule and how the rule benefits both sellers and buyers alike, the many different ways. We used expert witnesses to talk about commissions and how the market drives the commissions being offered and paid in particular markets. We use the expert witnesses also to show how brokerages make independent unilateral decisions about their training, about their offers, about their practices and services that they may provide. And we had a lot of testimony about choice, and that while 80% of home buyers choose to work with realtors when buying or selling a home, they have choice, because the other percentage don't. They may go it alone, they may use non-realtors, they may use other kinds of agents or services to assist them. So consumers have choice, and they continue to choose to work with real estate professionals, because it is a incredibly complex, expensive investment that many will make very infrequently in their life. So all of this good, positive testimony was provided to the jurors, a panel of 8 jurors. I'm at the conference now, and there's lots of rumors about what was or wasn't presented and what happened. So I'll just tell you about the jurors for a second to quell any rumors there. But the jurors were, the jury process means you start with this huge pool. We started with 80, and then it culls down. The judge eliminates some for bias, the plaintiffs eliminate some for bias, and the defendants eliminate some for bias. And then you have what the court systems of Kansas City have delivered to you. And we ended up with 4 homeowners. And 2 of them had used an agent and had positive experiences with their agent. The other 2 did not use an agent when purchasing their home. And the other 4 were either renters or lived with the homeowner themselves. So that was the makeup of the pool of the jury that had to decide whether or not the rule was anti-competitive. So now I'll just tell you briefly how they decided, and because it really amplifies one of the next things we'll talk about in the appeal. And this court got it wrong when it said that this was going to be tried by a per se antitrust analysis. A per se asks basically, if this, then that. If there was a conspiracy that had potential anti-competitive outcomes, then there's damages. But the rule of reason analysis and antitrust law allows or demands that the decision maker weigh the benefits and the pro-consumer and pro-competitive benefits to the arrangement, and ask, do the benefits outweigh any potential harm? So that should have been the analysis that was before the jury, but it wasn't. The jury simply was asked, did the defendants agree, conspire to force and follow and enforce the rule at issue? And the only evidence that they had no evidence of agreement. There was no evidence of communication, even understanding or knowledge, no whistleblower. There's no communications about commissions between any of the defendants. But the plaintiff just alleged that there is a rule, an association created a rule, and the rule was that the corporate defendants required their franchisees to follow it. And that was sufficient for the jury to find that there was a conspiracy. And then they looked at testimony from the dueling witnesses and determined that that led to artificially fixed prices being paid by sellers to buyer brokers. So the outcome was very disappointing. And then the number is even more shocking because it really lacked any kind of expert analysis. Basically, the plaintiffs looked at the data from the MLS and looked at all of the transactions by a broker who has a brand, lines up with one of those 4 brands, and used the amount offered. So they used the home price and the amount offered to calculate the damages to sellers. They did not inquire or find out if those homes actually sold once they were listed. And they definitely didn't look and inquire to see what was actually paid when it was listed. But the jury came back in only 2 hours. After 11 days of testimony, in just 2 short hours, they came back and determined liability. And so, now I think we're also going to talk about next steps and where we go from here.
Thank you, Katie. That was a great synopsis. So before we kind of jump into what's next and what are the outcomes that we're most concerned about, let me see if I can summarize a little bit of what you just described. Based on what you said and what I've read about the case itself. So basically at the center of this case is the whole concept that that a listing agent shares his or her commission with a buyer's agent. And the perception is that seller should not have to pay for the buyer's representation. Now, this may be just a matter of just nomenclature, but from what I understand, and I was never a practicing realtor, I come from the mortgage industry, but from what I understand, a listing arrangement between a seller and an agent, a listing agent, articulates basically what the responsibilities are of both parties and what compensation will be paid for those services. Now, let's just say that says 5% commission will be paid to the agent for these services. Then it's the agent's basic job to sell that property. And one of the ways that they do that is they post the listing on the MLS and they say, again, I'm paraphrasing, any seller's agent that brings me a buyer that's accepted, I will split my commission with them. Fundamentally, basically, that's what it says. So there's nothing that says the seller has to pay the buyer's agent. They're paying their agent. Their agent then is sharing half or part of their commission with another agent who's bringing them a buyer, who's providing them with a service, essentially, which I believe is a whole purpose for the MLS. The whole purpose of the MLS is to be able to display a listing so other agents can see it and potentially bring multiple offers to the seller so that they can get the best outcome of that particular sale. Seems pretty simple to me.
Yeah. I just completely agree. And that was the testimony actually that was also provided to the jury. They saw the listing agreements that each seller signed a listing agreement that explained the arrangement exactly how you just described it, Gary, that the seller would pay the buyer, the listing broker X amount and the listing broker was going to use part of that, any part of that, to market to buyer brokers and to incentivize buyers and buyer brokers, like real people who are actually in the looking for a home, to come and look at the house and bid on the house, thus helping the seller sell the home. And they signed the agreement. They testified that they received benefit from their realtor. They liked working with their realtor. They had a positive experience. They testified that they were once buyers. They were also buyers who received the benefit of this arrangement because they didn't directly pay for their buyer representation too. And yet they said, it just doesn't seem right. And so that's where we landed.
Yeah. And so I guess, again, at the center of the lawsuit itself is the notion that the buyer or the seller should not pay for the buyer's representation. And by doing so, the compensation or the commissions are inflated. And somehow, the consumers are being, overpaying for the services they receive. Now, you touched on something very early on that is kind of why we felt that NAHREP needed to get more involved in this particular situation, and that is the role that buyers agents play in the transaction itself. Now, I consider myself a pretty savvy individual when it comes to real estate. This is essentially the business I've been in for 20 years, or more than that, actually. I would not put in an offer for a home that I wanted to purchase without an agent. There's just so many variables, and I don't know everything about a particular market or a particular subdivision. I may not know all the latest laws and rights that I might have as a buyer in a particular state. I would want an agent representing me to help me through all of that. So I could only imagine what that process would be like for somebody who's has no experience with it, a first-time home buyer. Somebody who has never gone through the process before, doesn't know the pitfalls, doesn't know what questions to ask, and isn't experienced in making right choices. I mean, it's an invaluable service as far as I'm concerned. So the outcome that I'm looking at here is one where if we're saying that cooperation can no longer occur, and that's what my next question is going to be to you, and that is, is this going to be something that's going to be deemed either impractical or illegal potentially moving forward, and who basically benefits from that outcome and who loses from that outcome? Because that's the way I'm looking at this.
Right.
So
Really?
first of all, let me ask the question: what does this mean towards cooperation between buyer and seller agents moving forward, in your view?
Yes, really important questions and issues that we should all be talking about and concerned about. So first and foremost, the verdict itself does not mandate a change in our business currently. I want to just disclaim that message with this is an evolving process, right? You saw that, and I know we'll get to it later, but there were copycat suits filed right after the verdict. And so I just mention it to say that this is an evolving legal landscape that we are assessing constantly, working around the clock to make sure that we are navigating it strategically and towards an outcome that always allows for buyer representation to be accessible and affordable. And then also that eliminates the liability for our members who have relied upon this arrangement that has existed for over 100 years. The practice has existed for over 100 years. The rule itself has existed since MLS's formalized rules in the 1960s. So we want to make sure that we are navigating towards an outcome that ultimately removes liability for many of our members who have served consumers with this model that actually helps them. So real specifically, there's no action today that must change your business practices. In terms of what can you do to improve your business practices, we need to be doing what we have talked to audiences about for the last 5 years, which is two very important things. First, make sure that you are very clearly communicating with the buyer, with your buyer and sellers, with your clients, about the services you're providing, the value of those services. What are you charging? How are you getting paid? Why does that make sense to them and in their best interest. Those things have to be super clear. And when you use agreements, that is the best way to force the conversation. So that those conversations typically always happen when you have a listing agreement, because the seller is like, wow, well, you know, explain this to me. What does this mean? Why are you offering this to the buyer? Well, we should use buyer agreements too. That's the second thing that you could do today to really help move your business forward and educate consumers. When you use buyer representation agreements, you can negotiate how you're going to get paid. You can negotiate what you're going to get paid, but you're forcing the conversations that really enlighten the consumers, and then thus lead to them feeling like you really are their trusted advocate. But in terms of offering compensation, there's nothing that has transpired yet that would require you not to continue to offer. But we should be wary of future outcomes, as
Right.
you said. Yes. And that is like injunctive relief. Right now, there's no injunctive relief. Could they later argue for it? They could, and we'll be ready for it. But right now, they're not. But the who gets hurt, you said, if the listing broker doesn't compensate buyer brokers anymore, buyers have fewer options. Buyers will either decide to forego the representation. And as you said, Gary, they need it. This is really important. That buyer agency was created in the 1990s. If you can even imagine, it didn't exist before that. That's hard for me to believe, but it's true. And it was created because of this need. And so they would forego it because they couldn't, they need to put their money in the home, get the favorable mortgage terms, et cetera. Or if they're affluent, maybe they would pay directly. And then you see the disadvantage that creates. It would ultimately have the worst and most negative impact, as studies show, to minorities and to low income individuals and first time home buyers and veterans. As you serve veterans, you know that those who use VA loans are strictly prohibited from paying their buyer representative, and thus it becomes one of the other many terms that they have to ask directly from the seller, thus disadvantaging them in the competition for having the best offer to purchase a home. So there's a lot of negative repercussions that we want to avoid with further degradation of cooperation on the MLS.
Well, I would argue that a buyer's agent is every bit as important and valuable in a transaction, and maybe even more than the listing agent, in my opinion.
Yeah,
I don't want to get
absolutely.
in trouble for saying that. I do believe that.
They're both extremely important and valuable.
Both are extremely important. I just want to talk about one more thing before I invite Nora into this conversation. And that is, I read a statement that was put out by Steve Brobeck from the Consumer Federation of America, a very well-known and reputable organization that has a long track record of defending consumers' rights for decades, frankly. And the statement surprised me. It actually set me back a little bit, because it was advocating for a total separation, legal separation, making it basically illegal for broker cooperation to take place. It surprised me because my sense, and maybe I'm naive a little bit, is that the role of consumer groups should be, or is, and historically has been, to represent the interests of consumers that are at a disadvantage. Consumers who don't either have the means or don't have the experience or the wherewithal to be able to basically represent themselves in a complicated transaction of sorts, right? And that's what I look at. I don't think the Consumer Federation of America's mission statement is to defend the wealthier and more powerful in participants and entities in a particular transaction. I found it very ironic that you said early on that part of the case made by the plaintiffs was that somehow these big, powerful organizations were benefiting from this. But to your point, from what I see, who is going to benefit from an outcome where cooperation was no longer allowed? Well, I guess in theory, sellers, in theory, maybe not. It may not help them at all, but at least that's what I think they're advocating for. I think buyers who are wealthier and who have means will always be fine. Either they're comfortable representing themselves, or they can afford an attorney, or they can afford to hire an agent if they wanted to. But first-time home buyers, minority home buyers, people who have less means are definitely going to be impacted if they are not able to have an agent represent them without having to come out of pocket to pay for that representation themselves. It seems pretty obvious to me that those are going to be the individuals that are going to be most negatively impacted by this type of outcome, or the outcome that I think some people are advocating for right now. And I think this is a good opportunity to bring Nora in. So Nora Aguirre is our president-elect at NAHREP, but she also is a prolific agent in the Las Vegas marketplace. I don't know how many transactions you did last year, Nora. Maybe you can tell us. How many did you do?
Yes. So we closed 175 transactions. 150 of those are buyers,
So
approximately.
150 buyer transactions you basically represented last year.
Yes.
So tell me about your typical client. What percentage of them are Hispanic?
Yeah, 75% of my customers are Hispanic. I can tell you, Gary, that what I'm hearing, from the verdict and kind of the everything that's being spoken about, like this is absolutely, the right direction for the consumer. And, I sit back and I just look at the journey that many of my first-time home buyers have to take. And, I've been in this industry for 19 years, and I want to say that the journey for first-time home buyers is always a complicated, complex journey. But right now in this market, with the increase in rate, of course, affordability, and there is no homes in the market, a buyer now needs so much more than just the typical education resources that we were providing all these years. They need somebody on their corner, really, from the moment they begin to think about becoming a homeowner. They're already needing education and resources to learn about building their credit. How can they possibly save when, they don't have a lot of extra income in order to kind of save for that down payment? Maybe what organizations can help them come in with their down payment? Oh, and now what banks are actually providing products or programs that they would benefit from. So once they get through all of those obstacles and hurdles, now they have to enter a market where they know that they're going to be competing with, maybe move up buyers or investors or institutional buyers, cash buyers, of course, in the market. And so they're at a disadvantage all the way through. And many of us can agree that in our market, it's been a seller's market for quite a bit of time. So you tell a first-time home buyer, this is what you have to do. We're in this together for the next couple of years, and they sign up for it, and they're willing to do it because they obviously want to become homeowners. It is obviously the dream for everyone. Now, if we turn around and tell them, now you have to come in with an additional cost and an additional fee, whatever that fee may be, but it is definitely substantial. The only thing they're going to do is delay their process to becoming homeowners, or just completely give up on that dream. And we understand that, families that stay renters, they absolutely, that the path of being a renter never leads to true wealth. And so I can tell you that the education that we provide, and many of the members in the NAHREP organization, because we are passionate about this, it's to get them to that finish line. And we're willing to stay with them all the way through. Now, I understand that, they're saying, well, maybe it wasn't addressed, or maybe this wasn't explained. I think it's very clear if you really look at the journey of a first-time home buyer, whether it's Hispanic, veteran, our African-American first-time home buyers, just really the first-time home buyer, you will clearly see that it is a journey full of obstacles, and you absolutely need a lot of resources and support from a trusted advisor, usually that buyer's agent. So it's incredible to be in this place right now where we're addressing sellers, in this, verdict, and, how they've been, affected, of course, and not really take into consideration the voices of all of our first-time home buyers, which absolutely need advocacy. So I can tell you, in most recent, I have a family the Gutierrez family, they have 4 kids. The father's the one that's working. The mother's a stay-home mom. They've been living as renters for 15 years. Every time they've come, to see us, hey, you're almost there. You're almost there. You're only missing this. This is where we need to be. The market got harder now. All of a sudden, you need to kind of go back and let's get you a little bit more savings. And guess what would be the conversation now that I have to have with them again? Now we have to now turn this into a couple more years of you saving for this commission, or let's figure out a way how we can enter the market and find a way to negotiate with it, which at the end of the day is going to come out of the buyer's pocket, whether it's if we increase the purchase price. So to me, it's very clear that if we're looking at the consumer, we truly need to look at all sides in this issue. And so I think that, Gary, you can probably, lead with any other questions you may have for me. But this is something that that I'm very passionate about, not only because it's my business, but because I see the stories. I'm front facing every single day. And I see all of the struggles and everything those first-time home buyers are willing to do, and putting this new burden on them in this type of market will only take us back from the progress that we've seen in the recent years for our minority home buyers. It will take us back.
No, I think you made a very strong case for buyer representation and the value that you bring to a transaction, especially for first-time home buyers. But I think it applies to all home buyers, frankly. You didn't even talk about, the guidance that you provide them with respect to the actual property itself, and what to ask for, and property inspections, and how to read one, and so forth, so they know what they're actually getting into. The process is very complex and very intimidating for just about anybody. And I do fear that if the outcome that we fear the most, which is cooperation, is no longer something that is permitted, that people are going to try to go at it on their own. And there's going to be a lot of people that are going to get into deals that they regret, or they're going to enter into transactions, or maybe even get financing instruments that they don't fully understand. So the role of a realtor is invaluable in that regard. And so anybody who puts out the notion that somehow buyer's agents are obsolete or no longer necessary because everybody can go on the internet is just either kidding themselves, or just trying to pull over the wool over everybody else's eyes. Katie, one of the things that you pointed out from the very beginning is that you weren't even really able to make the argument that buyer's agents provide this value, that they didn't have to show that there were actual damages. They had to just show that there was this collusion of sorts that was going on. Is that correct?
Yeah, well, we did show that the great value that buyer agents, and we showed how the seller benefited from the work and services of buyer agents. And to Nora's very good points, we definitely highlighted how this world that the plaintiff is constructing would harm first-time home buyers. There are studies that show that, and our expert witness economists explain that very well as well. But the jury couldn't consider it. So while we offered that to them, the jury verdict form had 2 substantive questions before they asked for how much. And it was there an agreement to follow the rule? And did that lead to commissions being fixed? They were not allowed to consider what the rule, the benefits and the outcomes of the rule, other than if there was an agreement and if the jury thought that there was fixed or inflated prices. And that was a misstep. That was an error of law that we will challenge on appeal.
I didn't even know that was permitted. I always thought if I sued somebody, I had to show damages. I couldn't just sue them just out of, for no reason whatsoever. I mean, that's astonishing to me.
Yeah, it's everything about that trial is astonishing.
So Katie, let's talk about moving forward, basically. So obviously there's going to be an appeal that you are going to lead moving forward. What is the basis of that appeal? What outcome are you looking for? And then let's talk about things, as we wrap up at a more sort of global sense. What strategically should we be thinking about? What should NAHREP be putting out there? What role can we have in ensuring that we end up with an outcome that is actually in the best interests, not only of our members, but even more importantly, of the marketplace and consumers as well?
Perfect. Yes, great. Thank you. So in terms of next steps, there are many lanes we're following here, and in the legal lane, let's talk about appeal. In order to get to the point where we appeal to the Eighth Circuit Court of Appeals, which will be a panel of judges who are very versed in antitrust law, not a jury panel. We have to first ask the district court to undo what the jury did. We have to file motions that say you have to overturn the jury's verdict because it was wrong as a matter of law, and ask for a new trial. Those are motions that have to take place, and then the judge will have to rule. And if he does not rule in our favor, then we get to go to the Eighth Circuit. Then we get to make the case about the antitrust analysis being wrong. Then we get to make the case about several appealable issues about indirect purchaser and how the outcome and the damages are not supported, and hopefully get that ultimately overturned. In the meantime, we are also navigating the case in Illinois that will be filing a motion for summary judgment in there soon, that could proceed to trial in 2024. And now there's other cases being filed. The new cases against NAR, one of them named 7 new corporate defendants. So still, I just want to make the point that in terms of ones that NAR is involved in, all the corporate defendants are co-defendants are corporations that don't provide real estate services themselves. These are franchisors that license their brands to real estate service providers. And so we are strategizing ways to contain the spread of copycat lawsuits, because quite frankly, that's what happens when one class action gets a verdict, others swarm. And so we'll manage that, and we'll figure that out while we appeal to get the right outcome in this Burnett case. But what are we gonna do in the meantime? And that's another lane, and that's really the lane. Well, so in that lane, Gary, I'll be coming to you seeing if there's any kind of legal support you would want to help articulate the points that are most important to your members in an amicus brief or in some other way through that legal process. And then this other lane that you and your members and our members should be spending most of their focus and time on is how do we look at this as an opportunity to rise above, an opportunity to differentiate ourselves from our competitors, and an opportunity to educate the public and to get rid of this misinformation or to counterattack the misinformation. I mean, the media reaction to, and Nora mentioned this, the media reaction to the verdict is also astounding. It's frightening because of what you said in some of your headlines that you saw, that this is good for home buyers. It's absolutely not. And so we need more voices. And if you go to competition.realtor, you'll see a ton of messaging that we've created and that we've used in op-eds and commercials and every kind of social media campaigns, trying to get the message out, encouraging locals and states to do the same thing, get the messages out to your audiences, because it really is a battle for the attention and the persuasion of the consumers. And so the more people who are giving them the facts, and the more people who are giving them the truth about these potential outcomes, the better. And so I feel like that's another avenue that you guys could really take advantage of. And I saw in the Q&A some really good ideas about Spanish language ads and Spanish speaking audiences that, I think that's a great idea. If you ever wanted us to also amplify your messages there, that's we would love to do that.
We would love to chat with you about that for sure, because I think that can be very helpful.
Yeah.
So let me just, I'm going to just talk about a couple of things that you may not want to talk about, but
Okay.
I just want to put out there. So I've heard that the Justice Department is actually looking at this case. Who knows? They do things under a black box, so to speak. But do you guys, have you sort of gauged the likelihood that the Justice Department is going to weigh in on this and determine that the idea of cooperation is going to be deemed illegal? Is that a likelihood? Is that a very low likelihood? Why is the Justice Department even looking at this?
So the Justice Department is it's talking about a black box. So I just want to mention, if you drive offers of compensation off the MLS, where are they going to be made? they're going to be made in the shadows. How does that help fair housing? How does that help discrimination or access or opportunity, transparency or accuracy? That destroys all of the tenets of the MLS, which regulators used to acknowledge was a benefit. So did consumer advocates. So it is
Transparency.
yes, transparency. That would be destroyed if you can't use the multiple listing service to make these offers. But in terms of the DOJ, what do we know? Of course, there's lots of speculation. I'm sure that the DOJ and the plaintiffs' attorneys all know each other and have certainly communicated about what's transpiring in our case. But we also are in a lawsuit against the DOJ. And if you recall, they did file a CID, a civil investigative demand against NAR in 2019. We complied with it. We provided the documents and information that they requested, and we negotiated a settlement, and we negotiated an outcome, which changed some of our rules, but did not change the participation rule or the clear cooperation policy, which are at issue in the trial. And we adhered to it. Long story short, they tried to back out, right? Do you remember this? In 2020, we announced this settlement. 2021, they said it's a new administration and we don't like what the old administration did. We are going to unilaterally just renege on the deal. That wasn't fair. That's not right. The law does not allow that. So we, when we received the new investigative demand, we sued the DOJ asking for them to quash that new investigation. Well, earlier this year, the district court said, yes, we agree. And he summed it up at the end by saying that the government, like any other party, must abide by the terms of its settlement agreements. And so where we are there is that DOJ was trying to reinvestigate us. They can't because we reached a resolution, but they're appealing that decision. So on December, this is a very busy year. On December 1st, we'll be in the hearing, the appeals hearing, where we'll be arguing that case before the federal circuit in DC. So what are they doing? In terms with us, we're in litigation with them. In terms of what they may be contributing or talking to the plaintiff's attorneys, I'm not sure, but we certainly would anticipate that they've made their opinions known.
Yeah, and so let me just kind of piggyback on that a little bit. The Justice Department does not make law. They only enforce law.
That's supposed to be the case, yes.
Exactly, right? I'm just putting that out there. That is the case. They may have a little mission creep happening now and then, but their job is not to create law, but to enforce law. Now they have a lot of, what do you call, prosecutorial judgment that they can utilize, but that's a fact. Which also means if they overstep their bounds, then it may require legislation to address at some point. Now I'm getting way ahead of things, I know, and I realize that, but I'm asking those questions, or I'm putting it out there because I think that one of the things that NARUP is going to start doing is educating our elected officials, our members of Congress, members of the Hispanic Caucus in particular, about this issue so that they understand it before they start making their assumptions and reading headlines and listening to people like Steve Robeck. They start to recognize that this is a lot more complex than people realize, and there's going to be an outcome that at the end of the day is going to provide very unintended consequences if we're not careful. So I do think it's important for us to have those conversations with elected officials and maybe some of the agencies, because I do think, to your point, the public sentiment around this issue is going to matter a great deal at some point, if not sooner, certainly later as well.
Absolutely. Thank you for having that idea and strategy. Let us know how we can support your efforts because it's absolutely necessary and a great idea. So thank you.
Yeah, we're going to do that for sure. So we're going to wrap up now, Katie. I think this has been a very helpful and educational conversation. I don't know if you've noticed, but we had over 600 people register for this live. Most of them are parts of our chapter boards and leadership. There are literally hundreds of questions that have been submitted. We're going to filter through some of those, and I may send some of them your way. Hopefully you can provide us with some feedback so that we can share that with our membership as well. So this process is just starting. I'm looking forward to working very closely with you on this moving forward, because I do think it actually disproportionately affects our members and by extension, their customers. Nora, I'll let you kind of give us the last words here. And maybe it's positive or maybe it's a warning, but let's let you kind of wrap things up.
Thank you, Gary. Well, we certainly appreciate the time, and you know, I'm here, of course, speaking on behalf of our members, because like I mentioned, many have the passion to really help our communities become homeowners, because we understand that that is the way that they have a shot at building wealth for themselves, for their family. So this is a big deal for us. But most importantly, we're here advocating for our customers, right? The consumer. And I think Gary said it, it's really not just a Hispanic, Latino, or minority thing. It is really first-time home buyers. So I want to say here today that we are completely committed to making sure that we are the voice for them, as clearly this is not something, their opinion and their 2 cents on the matter hasn't really been expressed. And I don't think media is really picking that up anywhere. So we intend to do that. And thank you so much, everyone that joined us, all of our members. We look forward to continuing to keep you guys on top of everything that's happening. And please stay on top of, you know, our Sundays, Gary's blogs on Sundays, because those are going to be getting better and better, and probably helping you understand exactly where we're going. So thank you, everyone here that joined us today. Thank you very much to all the team at NAR. Thank you, Gary. Have a wonderful day.
Katie.
Thank you.
Thank you, Nora.
Thank you very much.